Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. Today, we're going to talk about the subject of estate planning. And wait, before you change the channel, bear with me. We look for occasions where there's an opportunity to teach, where you learn some stuff that's practical, that has application to your family and your plans, etc. So there's a teaching opportunity, but there's also a little bit of voyeuristic interest. I think it's fair to say.
You could say that, yes.
So this is one of those occasions. We brought in our expert on estate planning, Jim Gau from TuckerAllen. Jim is going to help us dissect a case. And this case study, it's interesting and fascinating, but it has lots of lessons, and not just lessons for rich people, okay? It's lessons for all of us. So I'll give you just a thin overview of what it is, and then, Jill, I'll turn it to you to describe it. So it involves a guy who owned a company for many years. He was CEO. This company had a great reputation, a great brand. He was dedicated to the company. He had kids. He had a girlfriend of many years, apparently, who had a key position in the company. And so what was surprising was to the family that when he died recently, that he had not informed his family at all of his plans regarding the stock with this company, who's going to control it. Now, this is the family business. So needless to say, it's set at the stage for potentially, not necessarily if they figure out a way to make up, but it set the stage for a whole lot of problems between the kids, the ex-wife, who was actually had a close relationship just before this man died. And then, of course, there's his paramour of many years, and she's sitting in a position of authority now with this company, and there was no warning to the other family members. And then there were some decisions made in the estate planning that we need to all learn from. So I'm just giving you a thin overview of what this involves. Jill, I'll pass it to you to sort of fill in this picture, and then we'll talk about the legal kind of the more technical legal perspective from Jim.
A lot of drama with this one. We're talking about Richard Robinson. He was the CEO of Scholastic, and we all know that publisher. Can name a list of well-known books. My favorite, Clifford the Big Red Dog. The
Hunger Games.
Games, yeah. Harry Potter.
Magic School Bus.
Magic School Bus, yes.
These are classic brands.
Oh, yeah. And this company is over a century old. It was started by his father, Maurice Robinson. So Richard took over in 1975, and he worked his way up the corporate ladder. So he passes away this past June while taking a walk in Martha's Vineyard. Much to the surprise of the family, at least they claim, he left an interesting succession plan. Did not leave it to his two sons, Reese or Ben, or even his ex-wife, who he rekindled a relationship with. And in fact, she had a role in this company at one time.
And may have had expectations, perhaps.
Sure. And they did rekindle this friendship, and she claims she was with him when he passed away. Didn't even leave the succession plan to his siblings. Instead, Iole Lucchese, who is she? Well, she's a 30-year veteran of the company, the chief strategy officer, and, important to mention, longtime girlfriend. So the family claims...
And younger.
Very much younger. He was 84. She's 53 years old. Okay. So the family is reviewing their legal options and determining what they do next. Now, this is a question I'd like to ask both of you. The family claims they were blindsided. However, Richard Robinson had said that he earned his stripes in this company, worked his way up, yet his sons never worked there. Ben owns a sawmill company. Reese is a filmmaker.
So neither of them worked in the company?
No. And I just have to imagine he was very disappointed that his son did not join the company, right? And wouldn't you think he would have expressed that over the years? So, okay, maybe they were blindsided about Richard Robinson leaving the possessions to Lucchese, but control of the company, this was a woman that worked her way up. She's been there 30 years. She was, in her 20s when she first started. Are you buying that they were really that blindsided?
I'm not at all. I've dealt with clients that, especially, it's always the loudest noise comes from the wealthiest clients' children. And so it wouldn't surprise me if they had something coming, especially with the quotes that they've given in interviews that say, I as a filmmaker, I thought of myself as an advisor to the company, but I didn't want to waste my 20s in a large corporation. Stuff like that, where Dad says, I earned my stripes. I started in the mailroom kind of thing and worked my way up.
Right.
And them saying, well, I don't want to waste my life in a corporation, that hurts Dad. And so I don't think they would have been surprised. I think they're disappointed for sure. And I think they anticipated being able to at least benefit off of this company.
Yeah, I think that is the key issue here, is that we can all understand that we may not have kids who want to be in the family business. I could say from experience. But I think that one thing our kids expect, irrespective of whether they're involved in the business, is they expect to participate in the family wealth, the estate. So it's possible to separate those two things. And in this case, you wonder, did they not want to be in the business because this woman, she occupied the C-suite, meaning she had lots of authority in the company. So they might have felt that they would have had to deal with her regularly, his girlfriend of many years. And maybe there was tension there.
Well, Ben claims he never actually spoke to her until after his father's death, which I thought was kind of
a little bit strange. Well, that just shows you how little he was involved in the company. If she was such an important person in this company and in their father's life, and he hadn't talked to her and met her or heard her voice until a phone call after his death. It seems a little estranged to me.
Yeah, you can have dysfunctional families, and it's hard to tease out what is a rational estate planner situation where you have a dysfunctional family versus an estate planner who's not rational, who's not considerate, who doesn't anticipate the things that are inevitable. And I think we can say this about the planning, and these are some of the lessons for all of us here in this discussion. For one thing, there was planning, so we can't say there wasn't any consideration. And we find this too with clients where they come into our offices and they sit down and they do have a plan in mind, but they have no intention of disclosing that plan to their family members because it'd be an unpleasant conversation. So they may go out of this world with a plan that they wanted and yet not having disclosed it to the people that had they known it was coming, may be a very ugly probate fight of many years and that consumes a significant portion of the estate would have been avoided. So I think in this case where there is this, I'll say, tension of some sort, for Dad not to have sat down with the sons and said, look, this is the plan and this is why I'm doing it. But he apparently, most of the wealth went to her as well. We should talk a little bit about that. Not only did she get a controlling interest in the company, apparently, but she also got what would be the better part of the total wealth of this man individually. Is that correct?
personal possessions.
Mm-hmm, yeah, and the kids seemed very blindsided by that. To me, it actually doesn't seem that far out of the ordinary. So she's named in his will as a co-executor with the general counsel of the company. We don't have the terms of the revocable trust, but I'm assuming she is also probably the trustee, if not a co-trustee with the general counsel as well.
Yeah.
And so in our trusts, it does say, so our tangible personal property, personal possessions section of the trust normally says there's a written list. If there's not, that if I haven't completed a written list naming certain people, then everything is to be divided equally among my descendants as the trustee deems fair and equitable.
And now keep in mind, what Jim's describing means that this takes place without even going to court. Remember, one of the virtues of a trust is that all this can be settled in a conference room at the lawyer's office, the day after the funeral, for example, meaning that there is no probate, there is no delay and no hassles as long as it's an asset that's within the trust. So this was set up in that way and continues. So he put all the assets in the trust?
Yeah, so normally when you do a trust, you do just a blanket assignment of personal property. So your stuff that doesn't have a title, the artwork, furnishings, clothing, jewelry.
Personal stuff.
Personal stuff.
So this wouldn't necessarily be the person's home.
No. So anything with homes, cars, things that have a title, it's very clear who owns those. I would imagine his house was probably titled in the name of his trust, but no way of knowing that.
Yeah. What he's saying, though, is that as to all those things that have a document of title, like a deed or a car has a document of title, those things you go ahead and name the trust as owning it. So that means that the trustees will go ahead and after the person passes away and look at the trust instructions, and they'll distribute those assets as they're instructed to. But the nice thing about personal property is that you can just have a list that you're describing.
Yep. Yeah, and so normally it sounds like in this situation, the way the document reads, and without seeing it, I'm completely ad-libbing the terms of this document, but I can kind of read between the lines having done this for over a decade. And so I believe what it probably says is everything goes to Iole, but if anyone, she knows my wishes and she can distribute any personal property to my descendants as she sees fit according to what I've told her. And so it leaves a lot of discretion up to the trustee, but trusts do that. They leave a lot of discretion up to a person you supposedly trust to be in charge of making those distributions.
But why would you put somebody, though, in that role that has a hostile relationship to your children unless that's your relationship with your children?
That's what I'm wondering.
Right. That person should be an extension of your values and your priorities. Mm-hmm. So the fact that he puts her, albeit as a co-trustee, still, you get a sense that maybe he intended for his kids to be disinherited is a strong word because I'm sure he gave them some stuff, but the bulk of his wealth went to this woman.
Yeah. And it sounds like he had done things during his life planning-wise to set up separate trusts that potentially, I think an article said it owns 5% of the stock of the company, which they are beneficiaries of. I'm sure there were agreements within the company, intra-company agreements dealing with what happens with the death of an owner, a shareholder. But outside of those during life planning steps that he took, it sounds like, a majority of his wealth and assets were this company, which is going to her.
I've got a question. Okay, a will and revocable trust were used in his estate plan. Why? What would be the purpose of using both?
So, as we had mentioned, when you set up a trust, you need to ensure that either the trust owns your assets, like the title to the house, the title to a car, during your life, or it's directed to the trust at death with a beneficiary designation or transfer on death. Anything that does not have either that title now or title at death, let's say it's always a Santa Saver account or a vacation account that someone just forgets about. If it doesn't have a beneficiary or an ownership to the trust, then it has to go through probate. And the will governs probate. And so what the will normally says is everything goes to my trust. Sorry it had to go through probate, but we don't want anything to circumvent the terms of that trust.
Gotcha.
Because if he didn't have a will and something had to go through probate, it likely would have gone to his kids.
Yeah.
Even more evidence that he didn't want anything to go to them.
Yeah. And in a perfect world, you wouldn't have a will at all. You would just have a trust, and you'd be sure everything went in the trust. And as long as that happened, as long as you didn't miss anything, then it's true. There's nothing to go through probate because there's nothing that's not controlled by the trust. And the trust owned it, so the trust didn't die. You just died, or the loved one died. But the trust continues on, and that's the reason it can go ahead and redistribute those assets without needing to go to a judge in probate. But the reality is that you almost always, there's stuff that don't go in a trust. And besides, a lawyer's a little presumptuous if a lawyer does planning and only does a trust for you with no will. That is a pretty big assumption on that lawyer's part that nothing's going to go wrong. Because if something goes wrong and it turns out that the trust doesn't own a particular asset, that's not likely to happen, but it can. I mean, it could just be that there was a wrong document of transfer was prepared. All sorts of little mistakes can cause that to happen. So you want to have this safety net that says, oh, it turns out it wasn't in my trust like I thought it was, but thank God I had this will. And even though the will, unfortunately, has to go through probate, the good news is it's still going to end up going to the same people that I wanted it to go to. So you still want the will as a backup plan.
Okay.
Yeah, we call it a pour-over will. That's the Google search term, pour-over will.
Pour over.
Because it pours everything over into the trust from the probate estate.
Now, is it in Lucchese's best interest to play ball? I mean, how could this legally play out? Very messy, I'm sure.
Yeah, well, I mean, she has, voting shares. She has, and in fact, they made an emergency motion in New York for a judge to basically get an order from a judge saying that she has the right now to vote because the company was stalling. I mean, he had died, and they have important day-to-day business decisions that no one was there to make. He had 53.8% of the company, and he was the CEO. So, that's one of the reasons why she maybe wants to play ball because if she can come to an agreement with the kids, the company moves smoother. It's not exposed to a stock drop because there's all this turmoil on the board and potentially a hostile takeover or something like that. So, yeah, I mean, that's one big reason. The other reason is the longer the fight, the longer the more the money is depleted because they're defending this.
Yeah, and damage to the company's value. This company might be a takeover target because it has these great brands, these series and characters that Hollywood and others, there's so much value in these characters.
Right.
So even though this is a stodgy named company, Scholastics, and I'm willing to bet none of you have heard of that brand. Actually, my wife had because she used some of their materials. She homeschooled our daughters. But most people, I don't think, know that brand, even though they know their creativity, their products and stuff. They know that. So this company could be a takeover target. It makes it more vulnerable, and everybody suffers if there's a fight in probate. And remember, if the family members have no incentive to not fight, why wouldn't they fight? Because if nothing else, they'll get paid to go away. So it really behooves, I think, this woman, Lucchese, it behooves her, I think, to try to work with these family members. And maybe that's the reason she made the phone call and extended, an effort to talk to these two sons in an effort to resolve this amicably, because they can make trouble. And they do own some stock. So in the best case scenario for Lucchese, she has these potentially rancorous minority shareholders that have the ability to be difficult. Very difficult.
Right.
Because minority shareholders have rights.
Yeah.
And especially if the minority shareholders are suing her, claiming that she isn't even the rightful owner of the majority share, meaning they can allege undue influence, they can allege fraud, they can allege coercion. All of these, I think, are losing based on just this history we're describing. This guy wasn't known as being frail mentally. He was apparently sharp up until the end. They had a long-term relationship. This wasn't a 20-something-year-old woman that came into his life in the last 6 months that was a caregiver. I mean, we see those cases which are ripe. Those are ripe for huge probate litigation. This doesn't have those hallmarks. So I think that it behooves everybody, including the family members, to try to come to a settlement. And I suspect that settlement is going to have her purchasing in some way their cooperation. And I think if I were her lawyer and you could put this to bed with some payment of money that may not be a large amount, lawyers are often fond of saying to their clients, look, you can pay me or you can make a settlement to the other side.
Right.
And now, quite frankly, some people are so bitter in litigation of this sort that they'd rather pay the lawyer. And of course, we don't complain too much about that. But the reality is it doesn't make sense when you can simply settle it and not have litigation.
I wouldn't think the ex-wife would have any claims, would you? I mean, I know she's saying we rekindled our friendship during the pandemic. I was there on his deathbed, but really, they've been divorced since 2003.
Yeah, she's kind of getting her 2 minutes of fame here, I think. She was, granted, she was a friend of his, but I also don't have any of my friends in my will necessarily, so.
But she was the mother of his kids.
Yeah.
Sure.
But he probably paid her off once already.
Uh-huh. And in trusts, we always say, I don't draft, your kids, your descendants' spouses in there, and on purpose. And so I doubt he would have carved his ex-wife in on his trust at death.
But Jim, how often do you have clients come to you that have family members and they tell you, I don't want to leave anything to them. I want to leave it to my neighbor across the street. How do you advise them?
Be clear is what I always say, because even if you don't have the incredibly awkward conversation after you've drawn this up, you could at least spell it out either in a separate letter, which helps a little bit. It's kind of that, I'll be gone, they'll read this and they'll be mad, but who cares, I'm dead. Or you put it in the trust itself, because, at the end of the day, that document, that trust document, that will document is what people are looking at to determine what your intent was. And so if you put in there, even if you put something cryptic in there, like I'm disinheriting, I'm intentionally not providing for my descendants in this trust or these kids in this trust.
For reasons only known to me.
Yeah, that's the cryptic way of doing it. Or you can say, because they ran over my dog or something, I don't know. But, you can either spell it out or you can do for reasons known to them, they're not getting anything.
Do you ever advise them, maybe it's a good idea to tell them now while you're alive?
So I always get the question, which of these documents that we just signed should I give to my children or should I give to, the agents? And normally the answer is the powers of attorney give to the people you've named, because those are emergency situation documents. You don't want somebody rifling through the house and you're in the ICU and they're trying to make an emergency surgery decision or something like that. Now, the trust is a little iffy because it can change. You can amend a trust at any time if it's a revocable trust. And so that may change. So giving those documents to somebody, you need to make sure you've given every amendment and you're keeping them updated, because then you've got a copy from 1984 floating around and you've got a copy from 2016 that's completely different. And if the kids have the 84 copy and it says they get stuff and the 2016 doesn't, then all of a sudden there is a really big angry mob on your hands. What
if the 2016 disappears?
Yeah, right. And then you've only got the old copy that really wasn't their wishes. And so it's tough to determine whether or not you give that to them. Most clients, the vast majority of clients, there's nothing controversial in these documents. So I say, if you want to give it to them, you can give it to them. I don't see any reason why anyone's going to be upset with divide everything equally amongst my kids.
You do see, though, it's funny, things on a milder level than what we're talking about in this case with Scholastics. What I used to see a lot are things like even a durable power of attorney. That was sensitive because somebody would have one child that they really had a lot of confidence in. And maybe this child wasn't the oldest, or maybe this child, the others would resent it for other reasons we don't know about. It could be just that the client thinks that they have to be democratic with their kids, perfectly equal. So they're reluctant to tell the kids what they've done and as you can imagine, as somebody who's acting as a trustee, and it's the same issue. So they just choose not to say anything because it's uncomfortable.
Yeah, and I have that. You'd be surprised. Well, probably you wouldn't be surprised actually at those decisions and how sensitive they do get, because you've got and some clients default to oldest to youngest because that's just easier and less awkward to have that conversation, or. We really don't trust our oldest because they're not good with money. Okay, well, is there one that's a CPA or an attorney? Yeah, there is. Okay, well, let's name them because that's an easy out for the parent. Yeah. They were more qualified to do it. And so, yeah, you're right. And clients, a lot of the times, they'll have 2 kids and they'll want them to be co-everything, which isn't necessarily a good idea because the majority of 2 is 2. And so if they don't agree, nothing happens and you're just deadlocked.
Right.
Yeah.
And so, steering clients away from the co-trustee or co-agents is sometimes hard because they don't want to even have that conversation.
Yeah.
Now, isn't there a clause that someone, I know we've discussed this before, someone can put in their plan that if one of their heirs challenges the will or the trust, they're automatically cut out? How does that work? And why wouldn't Richard Robinson have done something like this?
He probably did.
Right. It's probably there.
Yeah.
Yeah, we haven't heard about it.
Yeah, it's we call it a no contest clause or an interrerum clause.
Yes.
Yeah, we like Latin here as attorneys. And so, that clause normally is in almost every estate planning document. And I say almost with almost 99% certainty it's in every one.
But now remember, that only works when you're giving them something. So in other words, the threat is if you challenge this, then you lose your interest. So people think, whoa. But if you're not giving them anything,
If you're not named.
well, if they're getting nothing,
Right.
or something so little that they have no incentive to not fight, because then the interrerum clause or the no contest clause has no teeth against them because there's no incentive for them to avoid the fight.
Right. Okay, I'm losing nothing. I don't care. I'm going full bore towards this estate and I'm challenging everything.
So one of the tips we would say to you, as we say to clients, is be sure that those people that you most want to be sure do not come back and create a problem. If you put that clause in there, give them something, because sometimes clients object. They don't want to give them anything, and the price of having that clause means you got to give them something. And another thing, though, that people often do is that there's this tendency to believe that when they're gone, that they have to treat all their kids the same. So if they have a child that's very responsible, so they may be inclined to allow their trust to pay out immediately. But they have another child or children that have problems, whether it's alcohol, drugs, and they think that it's going to be offensive to those kids if they, for example, give the responsible daughter or brother all of their money sooner, and then have restrictions, like a spendthrift trust is a classic example. Something like that would apply to the other children. And I think the reality is, if you love your children, you do what's best for each of them, and you don't look for a single policy that's going to be applicable to all 3.
Tailored to each child's needs.
I mean, and if you think of it this way, you didn't treat them exactly the same during life. You didn't force them all to go to the same school. You didn't, give them all the same lunch money. You didn't say, buy one a car and then, we got to buy the other 2 a car now. Most people, it just doesn't work that way. And so, treating them like that at death doesn't make much sense when you didn't treat them like that in life.
You may have been easier on one child in life than another.
Yeah. And, I mean, they're different kids. They've got different personalities. And even if you're giving them all, let's say you're just dividing it equally, they don't necessarily have to have the same responsibilities over that money. You can put the responsible one in charge of the irresponsible one's trust fund. And so there's all kinds of options. But again, we're getting back to the awkward conversations a little bit.
And that's really, I think that's one of the most important lessons in describing this case today, is that those awkward conversations are probably important to have. It doesn't apply in every case, but in some cases. And what I think caused this particular article to make its way into the news as it has regarding this company in the last several weeks, I know Wall Street Journal had an article about this, about Scholastics. And I think that was driven largely by the contention of the family members that they didn't see it coming. Now, as we discussed a few moments ago, maybe they should have if they didn't. But they went to the press and said, this company, which has a big name in its industry, even though it's not a name that's commonly known on the streets, it does have a big name in its industry for the reasons that we mentioned in terms of their inventory and the characters they've created. And it's been around 100 years. So the public's interested in what's going to happen to this company as well as investors. And for somebody in such an important role, he's almost a fiduciary when you're the CEO of this company, and to choose to go out, and if we believe the family, there was no discussion with the sons or the ex-wife about what he was going to do, and that was in fact leave, virtually all of his shares to this woman, this girlfriend of many years. So that caused a bit of controversy, and people are asking, why didn't he handle it differently? So among the things we talk about today is we want to be sure that we communicate the point that it probably is a good idea to try to have a conversation if you're going to do something atypical.
Mm-hmm.
If you're going to do something that's not expected.
Just not Thanksgiving or Christmas or Easter.
Yeah. You want to choose your time carefully.
Neutral territory, public place.
Yeah. And nobody wants to have the conversation, and that's what happens is a lot of people figure, well, I'll do it next year, and they never get around to it. And maybe that's exactly what this man thought.
Yeah, I mean, he was healthy. He was 84 years old, so wasn't a spring chicken anymore.
But he was still working.
And they said he was
CEO.
a fitness nut, so he was in good shape, seemingly. But, I mean, Arnold Schwarzenegger looks like he's in good shape, and he's had multiple bypasses. So it's not necessarily what you look like from the outside and really how you may have a blockage. You may have an aneurysm or something that's sudden, and you just don't know that the next year's coming. And so estate planning is one of those things that you can easily put off. And I have every client pretty much that comes in that's over the age of 40 that has kids says, we should have done this a long time ago. Well, why didn't you? Well, you weren't planning on dying the next day, so it was easy to put off. It's the one thing that you can easily say, I'm not going to use this anytime soon, so we'll get it when we need it.
But I think COVID, the pandemic, changed that.
Oh, yeah.
I think a lot of people thought, we better have something in place just in case.
Yep.
Yeah, and we do know that the family is getting some assets, so we want to emphasize that he didn't, as you said a while ago, he didn't completely disinherit his family. So the kids are going to end up with shares of stock in the company. They'll still be rich by our definitions and yours, I'm sure. And so I think that it's really a question about the damage potentially to the company if there were a fight. That was a big issue that triggered a lot of press interest in this. The implications for employees. I mean, there must be 1,000+ employees. Do we know how many employees there are of this company?
I don't.
No.
I'm sure it's a large company though.
Right.
Yeah. So however many it is, we'll just assume that there are a lot of employees, as there must be. And what about them? I mean, to have not planned in a way to minimize the chances of some sort of division that invites a hostile takeover or a company to come in and take over the company under conditions that are not best for the employees or the owners. It's not a responsible example of stewardship on the part of a CEO, as well as a patriarch of a family.
Mm-hmm. Yeah, and even if the relationship between the kids wasn't great, and like we've mentioned, it probably wasn't.
Yeah.
They probably had an inkling that they were not going to get a ton or not have a bunch of, shares of the company and control of the company. Mm-hmm. Because he mentioned, that there were, at the end of the day, he worked up through the classes, up through the ranks of the company. It was only his father that ran it and then him that ran it. And now he's, kind of hurt that his kids aren't involved in it. Yeah. And they had to have known that.
Which is understandable. Yeah, you're right. They couldn't have expected. I'm not inclined to complete that sentence because I think that what they expected probably was to get half his fortune. Mm-hmm. They didn't expect to have a role running the company.
Yeah.
Right. I don't see, Ben, who owns the sawmill, working at Scholastic.
Right. So I think they knew that, but that would have required their dad to sell the company.
Right. Or they to sell the company. But now they're kind of saying, they're taking the position, well, this was a family business, always has been. We wanted to keep it in the family.
Keep it independent.
Did you, though?
Yeah. What evidence?
And, maybe they had the idea in their head of, these TV show companies where the rich heirs just come in and have an office for show only and the company's being run by, the board. And so they just wanted the profits off of it potentially. Not really, trying to throw these guys under the bus or anything, but there's a lot of things to think about as far as I can't imagine they didn't expect this, but also they're shocked by it at the same time. So it's kind of it's an interesting dichotomy there.
Yeah. It's true though that as you point out, they could have, with a company this size, they could have occupied a board position
Sure.
and hired a CEO, and the company goes on. Unlike much smaller companies where the owners work in the company and manage it, but at some level you can sit on the board, like at Standard Oil and so many large corporations we know of. It's family members that sit on there for DuPont.
Yeah.
Yes.
Yeah. I wonder, though, if he did leave letters.
He might have. Then they might have not come out. It's hard to say. And there's a lot here that we don't know. We don't know what the actual terms of the trust are. I mean, it's one thing to publish something in the news where it looks like, this is an inflammatory story where she's getting the company and getting everything. Well, maybe she's not. Maybe it's held for her lifetime for her to manage the company, and then the kids, get it after or something like that. It's really hard to say what that trust actually says, because normally it's more complex than what you can fit on 3 to 4 pages of the New York Times. So
yeah. Usually, whenever you have a trust, you have the opportunity to kind of develop a specific plan that you want and to have some control over what happens later. So rather than simply stating that the trust is to distribute the shares to her, there may have been provisions that the shares are held within the trust and subject to her doing certain things, as you indicate. So
I bet she knew, though.
She probably, I would say they've had these conversations.
He said she was his closest friend, and I really think she was told.
If I'm stepping into his shoes, do I hand my company off to my 2 kids who kind of seemed ungrateful to even be part of the company and didn't want to be a part of the company,
and bitter toward the person that is a key figure in the company?
Right. Or do I cede control to someone that's worked there for 30 years that I've had intense conversations with over the management and operations of the company?
He obviously trusted her.
Yeah. So, I mean,
She
to
was very
step into his
dedicated.
shoes and try and think the way he was thinking, it makes a little bit of sense that he would give it to somebody he trusts with his family business versus 2 kids that kind of seemed ungrateful that it even existed.
Yeah, so we keep coming back to the point that really it's not so much his plan as what the ultimate dispersal or allocation was, but it's the way in which he did it. I think there probably wasn't a conversation. I'm willing to believe that because there is such outrage on the part of the family. Although the family, I noticed that in interviews they're choosing their words carefully, and it reminds me of Paul McCartney and Ringo talking about Yoko Ono. I always wondered why they had previously said such bad things about her when she had broken up the Beatles, but yet when John died and they knew they were a partner with her on a hundreds of $1 million deal, now I suspect billion, and they were very careful in what they said. I was amazed.
Yeah.
Suddenly Paul McCartney was very tactful, very diplomatic in talking about Yoko. And it's because they knew they were partners. And she could have made a mess. She could have caused lots of problems.
Oh, yeah.
In their, I don't know what all investments they had tied together, but they were bound by certain investments. And until they divested themselves of that, they weren't wanting to create a hostile relationship. So similar thing here, I'm sure.
It's amazing how money can make you react.
Yeah, but I heard the family members being careful. I heard it may have been it's either one of the children or the ex-wife who is still hovering around. But she said that she's confident that they're going to be able to work it out. I heard things to that effect, and it sounds a little like Paul McCartney, where the family's thinking, look, we're going to be stuck with this woman, and we can either start calling her names. Mm-hmm. Which means that if it turns out that she does have the winning cards, the winning hand, and it does look like
well for them.
It does look like she has the winning hand, then all you're going to do is cause more conflict and get less out of the ultimate outcome. So I think that they kind of get that. So the interviews that I read, and just a few, but they sounded like they were optimistic that they would work things out.
Yeah. We're hoping for the best possible outcome. That's how it was phrased. And then the other one was The other son was more pathetic. It was like pouring salt into the wound, you know.
Yeah, well, you have to look sad and shocked to get a little bit of public appeal,
Right,
public
in order to get
sympathy,
the article written.
Or to get the article written.
Yeah.
Yeah, if you give boring comments, nobody's going to put you in there. And then you also have to be tactful, like you said. If you start calling her names, well, you know, they have a pretty slim chance of he was not, you know, elderly where he was, you know, undue influence, or they can say he was incapacitated. He was fine.
Right.
Up until the end. And who knows when these were drafted, he was probably even more lucid. And so they probably know in the back of their minds that if they're not nice and kind of encourage her to cooperate, they're really not going to get anything.
Mm-mm.
Yeah. And I guess that's an important thing to bring up in this conversation is that even though you write up this estate plan and you've got your will written and your trust written, that's, you know, your wishes, if they're not clear and there's a fight over it, it might get settled like any lawsuit gets settled. And so, you know, it's not necessarily, you know, I mean, at the end of the day, yeah, they're supposed to go by the terms of the will, but if they're wasting all the trusts or the wills or the trust money, wasting all of your estate's money, it's often better for everybody to settle out.
And and this woman, you know, you could not compare her to, say, someone like, what was her name? Anna Nicole
Nicole Smith.
Where she married the 92-year-old man. You know, this is a very intelligent woman. Worked her way through the company.
Well, and the fact that she didn't, I mean, they were together, it sounded like a long time, and she never, you know, pushed him to marry her. It doesn't sound like, unless he just shot her down every step of the way. But, you know, if she was really kind of going after this money and she would have done things to secure her rights as a spouse or fight to, you know, get shares of the company while he was alive, things like that.
Yeah, this bears all of the hallmarks of somebody who was lucid, who was competent, who was premeditative about the plan. This has all those hallmarks. You can imagine a continuum from, on one end of the continuum would be something like this, where there's been a long-term relationship, demonstrated loyalty, demonstrated capability in the company, and a contribution to the growth of the company in a substantial ways. And she occupied a key position with the company for decades as she rose up. So contrast that end of the spectrum with the one where somebody who comes in, they're a caregiver of a person who's frail and declining, and in fact, they're there because the person is declining, and there's a big age difference, and a relationship develops, and suddenly a will's changed. I mean, when you have that series of events, then it's going to end up in a will fight. It has all those classic marks of undue influence and coercion or fraud. But this doesn't bear those.
No, this wasn't a deathbed marriage and will execution.
No.
This was done potentially years and years in advance, and didn't. If you think it through enough, makes a little bit of sense.
Yeah. So we hope that this discussion was helpful to you. You know, we look for these occasions to learn from people who have particularly lurid and interesting situations, and we can still extract things that are helpful for all of us. Jim Gau, always a wonderful, informative guest.
It's always fun to be here.
We'll have to have you back soon because we're of no shortage of cases like this.
No, we're not.
So as long as there's sex, money, family conflict, envy.
Yeah, we need to find one with like a suspicious death or something.
Yeah. We'll have to. Well, I'm sure that one will come along. If you don't want to look one up, Jill, maybe you can find one.
I will do my research.
Yeah. So we hope this is interesting and to you as well as educational. We'll be back soon. This has been another episode of Elder Talk. Till then, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.